morning. Thank you for joining us. I am Stacy Herr. I'm with the Chamber of Commerce of Eastern Connecticut, and it is my pleasure to be with you all this morning. I want to thank Amber and Andrea for putting this together for us. I know we have a lot of questions. The Chamber does have some additional resources available to you. If you have any questions at all, we can help you out with that or put you in contact back with Amber and Andrea to address any questions. But please, following this webinar, you can join us on chamberect.com for a resource hub if you have any additional questions. So thank you so much, Amber and Andrea, for your time, and take it away. Thank you to the experts.
Thank you so much, Stacy. So welcome everyone to our webinar. We're very, very glad to be here. We really do appreciate the opportunity to talk with you today about paid leave. My name is Andrea Barton-Reeves, and I am the CEO of Connecticut's Paid Leave Authority. And with me today is Amber Forrest, who is the agency's executive assistant. I will be talking with you and providing a presentation on paid family and medical leave. And Amber will be helping us to monitor questions afterward. Please use the Q&A feature for questions because we can't really monitor questions in the chat in a way that allows us to answer them timely and on behalf of many people who may have the same inquiry. So I'm going to go off camera, so not a distraction, share my screen, and then we will get started. Okay. And then Amber, if you can just let me know when you can see my screen.
All right, we can see it.
Excellent. So many things to move out of the way for me. All right, so I'm going to start from the beginning. And here we go. All right. As I mentioned earlier, my name is Andrea Barton-Reeves, and prior to my joining the Paid Leave Authority, I was the president and CEO at HARC, which is a large nonprofit that supports people with intellectual disabilities and their families. I do have a background in insurance because I spent the first 10 to 12 years of my career at Chubb in New Jersey, which is where I'm from. I have an undergraduate degree in English from Rutgers, and I have a JD from New York Law School, and I have been active in the community, and I've lived in Connecticut for 26 years. Today we'll talk about the paid leave program, an overview of the current law and what the law will look like in 2022, the role of an employer, how people will apply for their benefits, what paid leave will look like in the workplace, including the exercise of the option of a private plan, registration, some additional resources, and then we'll have plenty of time for questions and answers. Let's start out talking about the Paid Leave Authority itself. The Paid Leave Law was signed into law in July of 2019, and part of that law created the Connecticut Paid Leave Authority. We will be serving a growing need among Connecticut families to allow people to take care of themselves or the people that they love without having to worry about their lost income. We have a twofold mission, and that is to provide pathways to accessible paid leave that is easy to navigate. And we also want to empower employers and administrators and healthcare providers by giving you tools and resources that allow you to navigate and administer the program in your workplaces and with your stakeholders and constituents. There are 5 primary responsibilities that we have at the authority. They are outreach and engagement. Again, really glad to have the opportunity to do that today. We develop the policies and procedures that are needed to run the program. We establish the trust fund contribution rate, which by statute can be no more than 0.5%. It can be lowered if there are resources that allow us to do so. We approve and audit the private plan process, and I'll talk about that a bit more. And we administer the claims for paid leave benefits. Here are some key dates that employers should be aware of. Registration with the paid leave program began on November 23rd of 2020. It remains open, and we are encouraging every single employer to register by March 1st. And there are a number of reasons why you need to do that. Those reasons are really in the middle of the screen, which is that is the only way that you'll be able to submit your quarterly electronic payments on the due dates that are listed here. Beginning in January of 2021, employers should have begun deducting the 0.5% of wages with a preparation to remit those to the authority. In February and March, for those employers who are interested in offering a private plan, we will have the submission, which can be done now, and the review for approval of those plans happening in the next coming months. By December of this year, our plan is to have our claims administration portal open so that claims can be submitted for review, because benefits begin on January 1 of 2022. Which employers are covered by the paid leave program? Those employers that are covered include all employers who have one or more people working in the state of Connecticut, even if your business is incorporated or headquartered elsewhere. And those businesses include not-for-profits and private sector employers with unionized workforces. Those who are sole proprietors or self-employed individuals may choose to opt into the program, but if they do so, they must remain in for a minimum of 3 years. Those employers who are not covered by the program include the federal government and some state of Connecticut employees, with an exception for covered public employees. That same exception applies to municipalities and local or regional boards of education, who are also not covered unless a different decision is made by their covered public employees. The only category of employer that is exempt without exception are independent, non-public elementary or secondary schools, also commonly known as private schools. So what exactly is a covered public employee? They are all of the non-unionized employees of the state of Connecticut. They will be contributing to the plan. The unionized employees of the state can participate if they collectively bargain to do so. And the same is true of the employees of municipalities or local or regional boards of education. So for those people that work for either a municipality or a local or regional board of ed, if the unionized employees of those two entities collectively bargain to participate in the paid leave program, then all of the employees that work at the municipality and all of the employees that work at the local or regional board of ed must participate, whether they are in the union or not. And you can see at the bottom of the screen that a municipality is a very broad definition that runs all the way from our common understanding of municipality, town, city, borough, through maybe less understood definitions, which include flood commissions and or any authority established by a special act or regional council of governments. So 0.5% that employers are collecting is collected and managed in this way. The employee contributes 0.5% of their wages with every paycheck to the fund. The employer is responsible for collecting that 0.5% and submitting that money and wage information to the authority. We then receive that information and we validate the wage data with the Department of Revenue Services along with the Department of Labor, which are two places where we can get other types of wage and income data. The contributions to the fund are deposited into the Paid Leave Trust Fund, which is managed by the Office of the Treasurer and cannot be used for any purpose other than for the payment of benefits and the administration of the Paid Leave Authority. Then the authority uses those benefits monies in order to pay for claims made and leaves that are taken starting in 2022. Let's go over a bit the leave laws themselves. What the reasons are that you can take leave and the lengths of what some of those leaves might be. So some of you may be familiar with job protection or maybe not. There are some leave laws that allow people to take time off from work. And although those laws may not provide for income replacement, they do provide for that person to be able to keep their job or return to their particular job when they return from leave. Those laws include the Federal Family and Medical Leave Act, which applies to employers of 50 or more. And then right now, as we sit here today, our law, our Connecticut Fmla, applies to employers that have 75 employees or more. And that will change come next year when that threshold drops down to one employee or more. Job protection still is applicable if a person is on workers' compensation or if they have circumstances that would make them eligible to exercise rights under the Americans with Disabilities Act, the Pregnancy Disability Act, or the Connecticut Fair Employment Practice Act, which some of employers, especially small employers, might not even know apply to them because of the size of their business. So come 2022, workers' compensation will continue to be a law that will provide some kind of income replacement as well as job protection. And income replacement will also then be available under the new paid leave law come next year. So let's take a look at where we sit now with our current FMLA and what it will look like come about a year from now. Our current law applies to employers that have 75 more employees. And for those employees to exercise their rights under FMLA, they had to have worked for the single employer for at least 12 months. It does not have to be consecutive, and 1,000 hours for the time period that immediately precedes the time they're applying for leave. Once they've met those criteria, they have 12 months of job protection. Sorry, once they've met the criteria, they have job protection, but they had to have worked at least a year. And once they have eligibility, they can take 16 weeks over a 24-month period. An exception to that is longer leave that's available from military caregivers, meaning a family member who's taking care of someone who's been injured during active duty. Also, right now, an employer can require an employee to use all of their accrued time, paid, sick, vacation, PTO, whatever form it comes in, to cover the time that they are off on FMLA. In 2022, the law changes considerably. It will apply to employers with one or more employees. There will no longer be an hours worked requirement for eligibility, and a person will be entitled to job protection, meaning they take leave and they come back to their job or an equivalent job after they've worked for an employer for 3 months rather than 12. 12 weeks of leave will be available in a 12-month period, but the 26 weeks of leave for military caregivers will remain in place. There will also be, under Connecticut's law, an additional 2 weeks of leave available if there's incapacitation during a pregnancy. And finally, a highlight to the new changes in the law is that while an employer may require an employee to use their accrued time off, they can no longer require them to exhaust all of their time. They must allow an employee to keep up to 2 weeks of whatever accrued time they might have. We use PTO in this example. They're permitted to keep up to 2 weeks of their leave. What are some of the reasons for leave? They are these under the statute. You can take leave to create or expand your family through birth, adoption, or foster care. You can care for a family member with a serious health condition or your own serious health condition, and that could include serving as an organ or bone marrow donor or pregnancy. As I mentioned earlier, there's special leave available for a family member who's been injured during active duty in the military, also known as military caregiver leave. There's also qualifying exigency leave, which is available when a family member is called to overseas duty. And what is unique to Connecticut is that up to 12 days of paid leave are available for a person who is a victim of family violence, which is also known as domestic violence. We do have a family violence leave law in the state, which many people are not familiar with. It does allow for up to 12 days of leave to address issues that arise out of family violence if you were a victim, and those victims will now be able to apply for those 12 days of leave through the paid leave law program. I think what's important here, what's important here is to understand that there is an expansive definition of family, and that now includes parent, spouse, child of any age, sibling, grandparent, and grandchild. So a person in come 2022 may be able to take leave to support or care for someone who's related to them by affinity. And what exactly does that mean? That means any person with whom the employee has a significant personal bond that's like family, listed in the statute, regardless of the biological or legal relationship. So I think the most accessible example of that here would be the bullet that's second from the bottom, where you may have a couple that is cohabitating, but they are unmarried, but they consider themselves to be in a familial spouse-like relationship, despite the fact that they have no legal relationship to one another. They may be needing the opportunity to take time off, either to care for one another, or in some circumstances, perhaps to care for a child or a sibling. And in those instances, if they needed to take time off, for example, to care for one another, to keep the example simple, they would be able to do so under the leave law with appropriate documentation when the law changes next year. How long can that leave be? So let's just review this a bit. For employers that have 50 people or more, obviously the federal FMLA is not changing. It still allows for 12 weeks of leave in a 12-month period, with the exception for military caregiver leave. In 2022, Connecticut's law allows for 12 weeks of leave, again, with an exception for military caregivers, 12 weeks, 12 days for the family violence leave, and an additional 2 weeks for incapacitation due to pregnancy. If a person applies for paid leave benefits at the Paid Leave Authority, we apply those same lengths of leave at the Paid Leave Authority as well. So what are the eligibility requirements for the paid leave benefits? We've already reviewed the eligibility requirements for FMLA and for job protected leave with the 3 months of job protection available once a person's been with their employer for 3 months. In order to access paid leave benefits, however, from the Paid Leave Authority, you had to have earned at least $2,325 in the highest earning of the past 4 of the 5 quarters before the time that you apply for leave. And that can be earned from one employer or multiple employers. In addition to that, you have to have either been currently employed or you were employed for 12 weeks immediately prior to the time you apply for your leave. If you're a sole proprietor or self-employed, obviously you're registered and you're in the program, obviously you can also access the paid leave benefits. And you must, of course, have a qualifying reason for leave, as one of the reasons that I noted earlier. So what is the role of the employer in all of this? So every time an employee asks for time off for what might be a potentially family and medically qualifying reason, it's a good idea to ask 2 questions. The first is whether or not that person has any job protected leave under one or more statutes, and whether that person has any income replacement. So they may have no job protection, but they may have income replacement, and that's why it's important to ask both questions. And here's an example of that. Let me just go back to the previous slide. It will allow me to do that. So here where you see that the person is maybe eligible for paid leave benefits, let's say that they've earned the requisite amount of money, they've made their contributions to the fund, say that they're currently employed, they have a reason for leave under the statute, but they've not worked with the employer for 3 months. They, in fact, would be, and they need to take leave, would in fact be eligible for income replacement while they're on leave, but they would not have job protection because they've not been with the employer for 3 months. And that is a scenario that could be very real, which is why I wanted to raise that as a specific example. So an employee can be eligible for the federal FMLA, the state, both running concurrently, neither of them, or there's no job protected leave at all. And that's important to know too, because we need to let employees know that. So if they are in fact eligible for income replacement, here are some critical things we think that you should know. That an employee can receive benefits from the Paid Leave Authority and some employer provided benefits at the same time, obviously depending on the terms and conditions of the employer provided benefits, and that's usually short-term or long-term disability policies. But those combined benefits from the authority and from the employees and employer cannot exceed more than 100% of the employee's regular wages. If an employee, in fact, is on workers' compensation, they cannot receive benefits from the Paid Leave Authority. At the same time, they're getting benefits from workers' compensation, and the same is true for unemployment in the rare circumstances that those apply. I'd mentioned earlier an example of how an employee may be eligible to receive paid leave benefits but not have job protection. That's something that you really should be thinking about. And the requirement of the use of accrued time is something that employers have the right to do under the statute. You can require your employees to use their sick, their vacation, or their other PTO as long as you know that they have to keep those 2 weeks for them. Finally, if an employer decides that they want to offer a private plan, then the private plan is responsible for making all of these determinations around benefits coordination, the requirement to use their accrued time. They do have to allow them to keep the 2 weeks, even if it's a private plan, and the blocking of receiving benefits if they're receiving workers' compensation. So an employee accesses their paid leave benefits from the authority in this way. They apply directly to the Paid Leave Authority for benefits. If they come to you as the employer and they say, okay, I have all of my documentation, I need 3 weeks off because I'm having surgery and I need to be home for that time to recover. Let's assume they have 3 months of service with you, so they have job protection. You can say, fine, you qualify for family and medical leave, but you don't have enough accrued time to cover any of it, quite frankly, because you've not been here long enough, they will then come to the paid leave authority for those benefits. We then validate their eligibility based on how much they've earned and whether or not the reason that they're seeking for leave is one that's covered by the statute. We then do a preliminary calculation of their benefit amount, but we validate the absence from work with the employer, and we ask if there's any offsets that they may be eligible for under their employer provided plans. And then we calculate the final benefit amount and we issue their payments based on their income and the number of weeks that they will be out. Formula, we often get this question from employers, how much will they get paid exactly? It is a two-part formula under the statute. The first is that if a person is earning less than or equal to the minimum wage multiplied by 40, which is very common, quite frankly, especially in the restaurant industry, when people are paid by lower wages but make most of their money by tips. If the person is earning less than or equal to the minimum wage, which is now $12 multiplied by 40, they get 95% of their base weekly earnings. If their base weekly earnings is more than that minimum wage times 40, then they get that 480 plus a formula of 60% of the difference between those numbers, what they earn and what the 480 is above that. But the maximum that anybody can get is $720 a week. There's a couple of examples that show how this formula might be applied to employees. So we've got Mike, who is making $375 a week, which we know is less than the 480, which is the minimum wage times 40. So he knows by statute he will receive 95% of his weekly wage, which for him is $356.25. Deborah earns considerably more, and so the formula in the statute says she gets at least a 480, and then she gets 60% of the difference between the 480 and what she makes every week. And for her, that's $132, so she gets $612 a week. You heard me mention earlier about the private plans. So some employers may choose to opt out of the paid leave program that the state is offering if they are offering an equivalent plan on their own. But that has to be done under certain circumstances. So the general statutes, section 31490, allows employers to have an exemption from the state plan only under the circumstance that they create their own plan. And if they do so, then it's the employer and not the paid leave authority that administers the claims for paid leave benefits. But those employers are not required to collect that 0.5% and send it to the paid leave authority. If they choose to collect the 0.5%, which they can still do, they have to use that money for the sole purpose of administering the program. But under no circumstances can the withholding exceed the amount of the contribution rate that is set by the paid leave authority, which I said before is a maximum of 0.5%. If an employer chooses to offer a private plan, they can do so by going onto our website, which is ctpaidleave.org, and choosing the option, I want to apply for a private plan. The requirements are these: that it has to offer the same or better benefits as a public plan, and generally a short-term disability policy will not suffice because it cannot cost the employees more than the public plan. It has to cover all of the employees that work in Connecticut, and the plan has to be approved by a majority vote of all the employees that work in Connecticut. And that for that particular employer, and that is everyone who's out on workers' comp, on disciplinary leave, on whatever it is that they might be, everybody who works in the state for that employer would need to vote on it. And those would not be criteria that would be met by a short-term disability policy. Okay, so if an employer chooses to move forward with a private plan, there is a process here that they need to follow. First, you need to register at ctpaidleave.org and indicate your interest to apply for a private plan. But before you can do that, you need to assure us that you have some degree of insurance for the plan. So you can either get an insurance policy, and there are now 15 insurers that are offering this coverage in the marketplace, or a self-insured plan that would be available with the securing of a surety bond that runs to the benefit of the authority for the amount of money that your employees would contribute to the plan. You then need to educate your employees by using something that we've called the plain language guide. So we've taken the entire statute and we've distilled it into a few pages of plain language that employers can use, and you can get that from either your surety bond issuer or your insurance company that will allow you to just explain the law in plain language, and then holding an anonymous vote. And once you've done that, then you go back to the website, you choose My Account, you click on your business name, and then you submit your application along with the documentation, which would be your proof of insurance, your plain language guide, and your proof of your vote in favor of the plan. You've heard me mention time and again that it's really important to register your business. Let me tell you why. You've probably heard me on the radio or seen me on television, but I'm just telling everybody, please register your business. And here's why. It assures your ability to remit those contributions beginning in March of 2021. You are required by statute to withhold the 0.5% of 1% and remit those to the trust fund. The failure to do so in a timely manner will mean that your business will be responsible for making those missed contributions on behalf of your employees. There is a very short window that the Department of Labor has offered as a catch-up window to the end of the second quarter of this year that will allow employers who probably haven't registered, haven't withheld for any number of reasons, but the most you can go back and take from any employee's one paycheck is 1% to catch up. If that 1% is not sufficient for the catch-up, then the employer is responsible for the remainder of those contributions that were missed. And that is why we keep telling employers, please register, please withhold, just do it. And also, the failure to withhold and remit contributions could affect your employees' ability to receive benefits, because we are looking for employees who have made contributions to the fund. So we don't want anyone to have awkward conversations with their employees about not having made their contributions. So that's why we're strongly encouraging employers to register. The process is very short. It takes less than 10 minutes. And if you go directly to the site, it will tell you how to prepare for registration. You create a short account on business.ct.gov, and then you complete the process. Since 42,000 businesses have done this, we know that it's a pretty simple thing to do, and we're asking everyone to comply. So please get started. Go to the site, download the checklist, register your business. I've talked about a lot, and all of this is available on the site at ctpaidleave.org. If your employees are asking questions about anything, we have an array of resources that are available for you on our site. If you go to the employer page on the site, you will find, and you scroll down to the bottom, this employee rights poster, which is a comprehensive overview and summary, essentially, of everything that is paid leave that's applicable to your employees. We also have a shorter version of that on what we call the employee rack card, which is just front and back, very small. A lot of employers have been downloading that and including that with this employee paycheck mailer that tells their employees that starting last month, they will notice a change to their paycheck. This QR code is on this paycheck mailer and on the employee rights poster takes employees directly to what's known as a contribution estimator, so they can figure out for themselves what 0.5% of 1% is. And they don't have to always be asking you what that is, because they can figure that out for themselves on the website. There's also an employee fact sheet. So we've provided the employee information in 3 different forms. We've got that feedback from users. Everything that I've talked about is in this 24-page employer toolkit. The private plans, registration, all of it is in that toolkit, which you can download. All of these documents are available in English and Spanish, as is the entire site. Again, I direct you to ctpaidleave.org and ask if you can engage in these 4 actions. Immediately go register. If you're using a third-party administrator or any third party to do your payroll, make sure they're aware of this withholding. If you're using a large payroll provider like ADP and Paychecks and those kinds of, they already know. They've known since last April. If they're telling you they don't know, that is not true. They do know. Please educate your employees about the withholding by using the information that we provided on the site, and visit the site regularly for updates. We're here to help you. We do not have a call center because we're small and we're a startup, but if you go to the Contact Us feature on the site and submit your question, we do have a small staff that answers questions within 24 hours. And if you do need to be contacted by phone, you can indicate that on that form and someone will call you back. And if you need a Spanish speaker to call you back, you can indicate that as well. We're closing in on close to 200 frequently asked questions, and there are videos that are available on the site for more information as well. And that is the information I have to share with you today. Thank you for your time. And then I'm going to stop sharing my screen and see if there's any questions we can answer. I'm going to come
Hi,
back.
Andrea. Thank you so much. So we
Okay.
do have a few questions in our Q&A. I'm
Mhm.
going to go ahead and start up at the top.
Okay, sure.
This one looks like it may be a multi-part question, so bear with me for
Okay.
just a moment.
Sure. Okay.
Are you saying that if one municipal bargaining unit bargains coverage under the Act, that all members of other bargaining units of that same municipality are required to participate also, even though they did not bargain to participate?
Okay. So this is an excellent question that comes up all the time. And I think the question that's being asked is, what if you work in a municipality has multiple bargaining units with different unions? So the statute doesn't really answer this question directly. What we're encouraging municipalities that have multiple units to do is to bring those units together as you would when you're bargaining with all of the units at the same time for, let's say, vacation time or some other term or condition of employment, and come to an agreement if you can, as with all of the bargaining units with all of the different unions before there's a decision made. We are not saying, I want to be really clear about this, that one bargaining unit for one union can make a decision for bargaining units in other unions. That is not the case. But as the statute is currently written, it appears that it was not contemplated that some workplaces, not just municipalities, would have multiple unions that obviously represent multiple constituencies. So it's best to work with your employer, their labor council, your representatives to come to an agreement as to what the final outcome would be.
Thank you.
You're welcome.
The second portion of this question is, my reading of the statute is that if a bargaining unit negotiates their inclusion, then all non-union employees of the municipality and the members of that particular bargaining unit only are covered, but that the other bargaining units are not covered unless they do bargain inclusion.
That is true.
Okay.
Yeah. Which I know can be very confusing, but that is the way the statute currently reads. We have let the legislators know that there are some, how can I describe it? Complications in workplaces that have multiple bargaining units, and for them to consider some clarification on that if there's ever any change made to the statute.
Okay. Will there be regulations that will be forthcoming that will get into some of these details more, such as the claims process, how an employer may know the status of the claim, whether one has been submitted, pending, or approved, and how the job protection provisions work when notice is merely applied when a claim is submitted?
Right.
After leave is concluded.
Yeah. So so they wouldn't necessarily be regulations, they're policies, and we're writing those now. And we're actually relying also on and getting advice from other states who already have more established paid leave programs. And when I say more established, they're a year or two ahead of us. So for privacy issues and to protect the health information of employees that come directly to the authority and apply for their paid leave benefits, the notice will be rather limited. So you will know when an employee is applying for leave, if they made a claim, which I outlined in the slide that kind of walked through how employees apply. You'll know, we will tell you the length of time that they will be out. We cannot share the reason for leave because that's a violation of HIPAA. We've been advised that that's very clear. We cannot share that. And the estimated amount of time that they'll be away and when they plan on returning. So employers will know that information, but that's probably the extent of what we can share. And if in fact the employee comes back to us and says, I need to take more leave than I had originally applied for, then they will be redirected to their employer. We'll notify you that we've received information that they want to have more leave, but we're going to tell them to go back to their employer and have that conversation with them, because we're only approving them for the time that they have approved time away from their employer that's been approved between them and their employer.
Will there be model forms available for use for companies in handling leave requests fall under the Connecticut paid leave?
Yes, there will. You will not have to fill out the forms. You will not have to create your own form. We really actually prefer you not do that, quite frankly, because they may not always include all the right information and they may ask things that you shouldn't. So we've had some very enterprising employers come up with their own form, and we've taken a look at some of those, and we will most likely take the FMLA forms that are being used now by the state and do some modifications to those for the paid for the new FMLA. So please don't feel like you have to do that on your own. We'll let you know when those are available. They'll be on the website. You can download them and you don't have to worry about that. We'll do that.
Okay. How do you anticipate this process will work when an employer has a vendor who manages their leave? Will you still be going to the employer to identify time off or offsets?
Well, I think that depends on how the employer directs their employees. So if I'm understanding the question, it's you may have a vendor that is doing all of your leave management for you now, maybe already managing your FMLA or your ADA or your other kinds of leave. This would just be another type of leave that they would manage for you. So if your process is that your employee goes directly to the vendor and lets them know of their leave and manages all the forms being completed and granting the leave, knowing what the FMLA leave rules are, then that process shouldn't change. The only difference is now that employee once they get their leave granted would then come over to the paid leave authority in order to get the income replacement. That would be the only change. But your leave management company should know that, and they should continue to just apply the changes in the law and ask the same questions to determine eligibility and then send the person over for income replacement.
Okay, thank you, Andrea. Will there be regulations as to how the voting process will work for those employers that will be seeking a private plan?
Yes. So there are, let me just preface this by saying that we hold webinars on the private plan itself and how the process works. So if you have an opportunity to either look at a video that we have or we're scheduling a few more, then I really would strongly encourage you to go to the website and sign up for one of those, because I get into much more detail, as does Erin Choquette, our general counsel, about how it works. But generally speaking, we are not prescribing to employers how the voting process works, because they've asked us for flexibility and not to incur more expense by maybe purchasing an app or some sort of fairly expensive voting mechanism that they'll probably only use once. So it just has to be anonymous and non-coercive. And when you use the plain language guide that we've created for you, the question that you have to ask is the question that's in the guide. You cannot change that question. And it really, I'm going to just paraphrase it. It is, do you want the employer's private plan or do you want to go to the public plan? That's it. Because so many of us have been in the voting booth and there's a referendum, let's say for a new road or a library, right? And then you need a PhD while you're standing in the voting booth to try to figure out exactly what they're asking you and what you want to vote for. We didn't want that to be the case for any employees. So the question's very simple so that everyone in every workplace can get it. However you hold the vote, and the other thing I should say, it needs to be auditable. So that means that we at the authority, if we have a question about the vote, need to be able to go back and literally figure out how you held the vote. If you're using paper ballots, you should keep them somewhere because we might ask for them. If you're using SurveyMonkey, or there's a whole lot of different apps that you can use to count votes electronically, you should hold on to those results, because if there's a question, we're going to come back and ask for that. And that's essentially it. We do have 2 employers that have already submitted their applications, and both of them used a SurveyMonkey format, which was fine. I think they paid $25 for it, and they had the yes and the no, and then they sent us the report. And it was really simple. So that was it.
Okay. And while the employee is out, how does the employer continue to get deductions for the medical, dental, and retirement from an employee?
So you broke up a little bit, Amber, so I didn't hear the whole question.
While an employee is out on leave, how would an employer continue to get the deductions for the employee's medical, dental, and retirement programs?
Right. So the employee is responsible for paying those. We don't deduct those from the benefit. So if employees are out now, so I can just refer to my own experience that we were requiring the employee to either pay those in advance if they could afford to do that, or they had to find another way for us to pay it, or we would withhold it from whatever other pay they were getting from us in their last paycheck, which the Department of Labor would permit us to do because we sought permission to do that. If they fail to pay, and that's your company's policy that they have to pay their portion of their health insurance and other types of benefits, and they fail to do so, then employers, as we know, they have the right to discontinue those benefits if the employee has failed to pay. But if they're receiving, in some instances, 95% of their pay, then we will let them know in the notice that we're providing, which we're actually drafting now, that we're giving you this money, but you have to know that you may have other obligations, which would include maintaining whatever benefits you're paying, your portion of the benefits that you're paying for your employer. Make sure you pay that, because if you don't do that and they cancel it, we're not responsible for that, and neither is your employer, because you still have that obligation.
Okay. We have a question here regarding the timelines. So the question is, did you extend the deadline for approval of the private plan for Q1 from March 1st to March 31st?
We did not.
Okay. Are there deadlines as in May 31st, August 31st, and December 1st?
Meaning, is it rolling? We're not encouraging the rolling for the private plan right now, because we need to make sure that employees have some certainty around whether the withholding that you're taking out right now is going to be submitted to the paid leave authority, and if they're moving forward. If you need an extension in that deadline for whatever that reason is, you need to reach out to the paid leave authority directly through the Contact Us feature and let us know that you need an extension. But right now, we're really asking as many employers as humanly possible to make sure they get their applications in by that deadline that we set.
Okay. Next one is sort of around residency, but it's more about the residency of the employer themselves. So if an employer has registered themselves in Connecticut, let's say for sales tax purposes, doesn't have any employees working in Connecticut, is there a need then to register for Connecticut paid leave?
No, not if you don't have anybody working in the state. You don't.
Okay. Will the employee contribution increase after 2022, or is that a set amount moving forward?
It's the 1/2 of 1% is a set amount moving forward. So the statute caps it at that. And it also caps the contribution at the Social Security contribution rate. So anyone who's making more than, I think right now it's at 147.8 in 2021. If you make more than that, then we don't collect the 0.5% above anything over that. It's capped at the Social Security rate. So it doesn't go above that, and it doesn't go above 0.5%.
Okay. Let's see. Does the employer supplement their application by providing the final policy document to the paid leave authority within 60 days of the publication of the policy? Filing guidance notice.
Yes, so it's a great question. So yes, it's 60 days after we publish the filing guidance notice. So we're actually working with the Connecticut Insurance Department now on the filing guidance notice, so that we can get them with this close to our final draft for their review. Then there's approval by our board, and then then we have to put it out for public comment. It's a fairly long process. Once that is done, then that filing guidance notice becomes final and approved by our board, and that's when the 60-day clock starts running. So there's still some time, and we know that insurers have asked us to give them a bit more time to actually create the product. So the compromise that we struck, we were actually glad for their suggestion to just have the declarations be sort of a proxy for a full policy right now, so that the private plan process can move forward, which is what Massachusetts did. So we thought it made perfect sense and did the same thing, and appreciated their input around that. But the 60 days starts once the plan is finalized and it's actually issued after board approval.
Will part-time and temporary and seasonal employees be eligible for paid leave as long as they've been with the company for over 3 months?
So they will be eligible for paid leave as long as they meet the earnings threshold, the 2325, in the highest of the 4 of the 5 quarters immediately preceding their time that they applied for leave either currently working or they had worked 12 weeks prior to the time that they applied. The 3 months is job protection. So as I mentioned in my example earlier, there might be circumstances where a person does not have job protection, but they otherwise qualify for leave, and they can take that, but they may not have a job to come back to. So those two things aren't necessarily related.
Okay.
And yes, it is part-time, seasonal. Yes. Yeah. All those things are true.
Will there be information released on how employees should file paid leave for their taxes, or will it be included in a company's W-2?
File leave for, are we talking about the withholding itself or when they receive their benefits?
I think it's for how they would file their taxes.
Okay. So, all right, let me answer it both ways then. If the question is whether or not the person will have taxes withheld from their leave benefit, then they have the option of either taking that benefit without taxes and the authority issuing a 1099, or we withhold taxes based on their income in the appropriate tax bracket, and they receive that money net of all those taxes. So that's the benefit side. On the contribution side, that is considered a post-tax contribution based on the FICA number, and it should show up on their pay stub, and it should show up on their W-2 as well in a separate box.
If you're registered as a business but have a third party that does your payroll, like QuickBooks, who is responsible for submitting the quarterly payments to the Connecticut Paid Leave Authority?
All right. So if you're using what we consider a third-party administrator is an entirely different entity that does your payroll for you. So if it's your tax accountant, or or as I said, some of the larger payroll providers, or some have what we know as a PEO, if they're responsible for making sure that your payroll is issued on time, then they're responsible for the withholding and for the remittance. So we're looking to them to do the whole thing. Some have said, we won't register for you, but we're responsible for everything. So we would be looking for that third-party entity to submit it. If you do your own payroll using QuickBooks, then you're responsible for submitting the contributions starting in April at the latest.
Connecticut paid leave includes a reason for their own medical condition. This will overlap with short-term disability benefits and need to coordinate. Understanding that during your presentation, you indicated you would go back to the employer to ask about offsets or other leave disability benefits the employee is eligible for, but if the employer has a vendor who manages this process, how do you anticipate that coordination will work?
Then we will talk to, so I can't give a specific example because what we're learning, and we already know this, is that every short-term and sometimes longer-term disability policy has different terms and conditions that the employee needs to meet before they're eligible for that. But we would just talk to your third-party administrator or your leave management company to determine what that eligibility or what that coordination might look like. There are some short-term disability policies that require that the employee exhaust any state available benefits first before they can access their short-term disability. So that's something we would need to know. If, for example, the person is accessing leave for intermittent leave, there might be circumstances where a person would get part of their leave from the paid leave authority and part of their leave from their short-term disability policy. There's also times when an employee may have enough accrued time and they may say, you know what, I really need 100% of my benefit of my pay rather than, let's say the person earns more than the minimum wage and they would be capped at the $720. I actually need to get my full paycheck. So, and they may, or maybe they'll get more with their short-term disability. Maybe, the 720 is not even close to, let's say, with the 60% of wages they would get under the short-term disability policy. They may access that first if they're permitted to do so. And then when they've exhausted that, they would come to the authority for the difference, or they may access their policy for the 60% and come to the authority for the 40. Those are the kinds of discussions and questions that we would be having with the employer and the employee. And if you're using a leave absence management company, that's what we're talking about with benefits coordination. And then we would determine what our portion would be and what the employer's portion would be, so that it never exceeds 100%.
Okay. Can you still apply for a private plan after March 31st, or is it just not recommended, or is it not allowed?
No, you can apply for a plan after March 31st. We're trying to, because we've had a lot of employers and the insurance industry really speak to us about sort of having, these are my words, these are not their words, sort of a closed universe around having some certainty about when their plan will be reviewed, when their plan will be approved, and the communication that they want to have with their employees about whether they're going to the public or private plan and when they're going to hold their vote. So that's why we're saying, based on that feedback we received, we really want to hold firm to that date. Plus, we certainly need to know sooner in this year, since this is the year that we're funding the paid leave program, than not, how many employers and what sizes of employers are likely to go with a private plan versus those that are going to come into the public plan, because that directly affects the solvency of the fund, as we know, right? Because it's just simple math. The more people that are in a private plan, or fewer people that are contributing to the public plan. Also, it's important to remember that the authority has the right under the statute to deny a private plan if it in fact threatens the solvency of the public plan. I know a lot of people don't like that provision, but it does exist. So the sooner that we can know that, the sooner we can make appropriate decisions around the private plans themselves. And so we can understand what the state of the fund looks like, how many private plans we need to look at, and then sort of adjust what we're doing accordingly.
Okay. Who is the policy filing guidance notice directed at, employers or carriers?
You keep breaking up, so I missed the first part of what you said again, Amber. I'm sorry.
Sorry about that. Who is the policy filing guidance notice directed at, employers or carriers?
Carriers.
Okay. And does the policy filing guidance notice, will that be issued after carriers get to submit their policy filings to the state?
We're hoping it will be ready before. That's the goal.
Okay. And what if the carrier's policy hasn't been approved yet within the 60 days after the policy filing guidance notice issuance?
We're hoping also to avoid that circumstance, but if it has not been approved, then we're working with the Connecticut Insurance Department to try to expedite the approval, or figure out why the approval hasn't happened, or if there's an outright denial, to try to get that moved forward, because we know how important that is. So we don't want it to stop. If the question is, does it stop the process of the private plan being approved? The answer is it might, but we're really trying to not let it do that. That's why we offered the option and accepted actually the very strong and appropriate recommendation that the declaration stand in the stead of a full policy until a full policy can be approved. We really want to make sure that the employees who have voted on the plan get what it is that their employers have promised them, and the only way to do that is to see a full policy, because the declarations and the private and the plain language guide are really just the first step in that process. So we're just really trying to work hard to make sure that the full policy, it represents what was represented to the employees. And if there's no significant difference between what you told the employee in the plain language guide and the declaration, then we don't see a reason why your policy wouldn't be approved, unless you're missing some other regulatory piece that we wouldn't know about, that that what we call CID, the Connecticut Insurance Department, would be looking for.
Okay. Is there a waiting period before paid benefits conferred on an approved claim?
There is no waiting period in this statute.
Okay. And can employers change their mind to create a private plan in the future, or would there be a penalty to the employer?
There is no penalty. No, you can decide to go into the public plan and then change your mind, and vice versa. You can have a private plan and say, you know what, yeah, I don't think so, and then come back into the public plan.
Okay. If an employer requires employees to use accrued paid leave, do the days covered by the accrued paid leave count towards the paid family medical leave allotment?
It's a great question. Someone asked this question last night too in a webinar, and the answer is that it really all depends. So it can create a situation that we call stacking, where the person can access their eligibility under paid leave, but not necessarily access their eligibility under federal FMLA. So the person could use their state leave and choose to use their accrued time for that, but still have up to 12 weeks of eligible leave under the paid leave program, if that makes any sense. So an example of that would be, let's say the person has a serious health, let's say it's some type of replacement of a joint or an organ donor or an organ transplant. Oh, looks like Siri's trying to talk to me, don't know why. Or an organ transplant. They may, for whatever reason, decide that, okay, so I need 100% or closer to 100% of my income replacement. So they will use their accrued leave, and maybe they'll use 6 weeks of their time under Connecticut FMLA, but never access their paid leave. They will still have 12 weeks of paid leave, but they may not have full 12 weeks of leave to take. But they also then may take leave under federal FMLA for a different reason, and then they'll still be able to access that leave, even though that's not paid. But then they could come back later in the year and have another reason that's covered under the Connecticut FMLA that they may access both their Connecticut FMLA and the paid leave for at the same time. It's a long way of saying, yes, that can definitely happen. We can anticipate circumstances under which you may see that, and employers should be prepared for that, because the reasons for leave under the new FMLA for Connecticut and the federal FMLA don't align nearly as well as they did before. So running those two things concurrently is going to be really challenging, especially since the time periods for job protection are now so different from one another in one statute compared to the other.
Okay. The benefits payable taxable. Would FICA be withheld from the benefits payable?
The benefits paid to the employee is, I think that's the question. So
Yes.
You're right. Okay, so the statute allows for the employee to choose the option between receiving the benefits without any taxes withheld. And under those circumstances, we issue a 1099, or they can have their taxes withheld as if it were wages, even though they're technically not wages, and we would withhold accordingly based on their income circumstance and where they fall in the income according to the IRS tax code.
Okay. And will insurance carriers issue a W-2 or a 1099 to employees that received paid family medical leave benefits through their private plans?
So whoever is managing that for you, I don't think your insurance carriers are going to do this. They'll probably be looking to your employer benefits department to do that. The insurance carriers, as far as they've expressed their role to us, is that they will be offering policies and coverage. Some are actually offering the policies, the coverage, assistance with the voting, assistance with your application, and leave absence management. There are some that are offering comprehensive packages, which I know. I don't know which ones those are. I guess you'd have to speak to individual carriers and see what they're offering, and if that's a financially feasible option for your organization.
All right. Thank you so much, Andrea. That concludes our questions, and we are right at 11 o'clock. Stacy, I'm going to pass the ball on to you. Thank you.
Thank you. Thank you so much, Andrea and Amber, for your time and your expertise. My goodness, you guys know everything, and we're real superstars. I know that
we learn something new every day. I don't ever want to be in a place where I know everything, because that means I'm not open to new ideas. And we get a lot of great feedback from all the questions that people ask. You asked terrific questions today, so thank you very much. We appreciate the opportunity.
Yeah, absolutely. Thank you. If anyone has any additional questions, you can visit the Connecticut Paid Leave website for a hub of resources. You can also visit chamberect.com for resources and recordings. YouTube, there's just a whole host of resources available. But if you have any additional questions, please feel free to reach out and we'll help get you directed to the right place. Thank you so much, and I hope you have a great day. As Amber mentioned, this recording will be sent to all attendees within 2 days, and we hope to see you soon. Have a great day.
Thank you. Have a great day, everyone.